Good afternoon, Jennine.
Good afternoon, Frank.
Um, Thanks a bunch for making the time to talk to me today because I am sure, and you'll tell us why, but that you've had a pretty full-on slash crazy day. Um, you are a lawyer at Global Legal Action Network, and today the High Court, London's High Court, has ruled that Britain's decision to allow the export of F-35 fighter jet components to Israel by the British government, despite accepting that they could be used, in breach of international humanitarian law in Gaza, was lawful. Can you first? What's your reaction to this verdict?
Yeah, we're disappointed by this verdict. We're not 100% surprised by it, but obviously we were hoping that the court would do better than this. But we see it as a one setback on a much longer journey, and we're considering the verdict and considering whether there are grounds to appeal against it. And we will continue the work that we're doing to try to hold the UK government to account.
If you can, like, maybe explain in a few words, like, so the court agrees in a way that these, I mean, components once installed, I guess, in the F-35 fighter jets could be used in breaches of IHL, so international humanitarian law. It's still okay for Britain to send them to Israel. So how do you come to this conclusion?
Yes, it is hard to follow, really. It beggars belief. So the government made a big concession during the course of this case. In fact, this case forced it to. In September 2024, it found, like you said, that there is a clear risk of a serious violation of international humanitarian law with Israel using weapons supplied by the UK. And that is why in September 2024, the government stopped sending to Israel all other licenses for military items, all except the F-35 parts that go into the global supply chain. F-35 jets are the most lethal fighter jets in the world, and Israel really relies on them in the relentless bombardments that it carries out in Gaza. So that is really important, and that's why we continued the case. And the government's argument has been that if they were to stop the UK supplying the components into the global supply chain, that the government has been saying it can't just separate out the parts that end up in Israeli planes. It would have to stop sending the UK-made parts to the whole global supply chain, and that would have knock-on effects for international peace and security, what would weaken NATO, for instance. So its defence was really pushing the risks to national security, and the court bought that. The court showed extreme deference to the executive and basically didn't really want to go near that. It's a high threshold to show that a government has made an irrational assessment. We obviously think it did. We think the court was wrong. But it is sadly true that at the moment the courts are showing this great amount of deference as soon as the government mentions national security considerations. We say they shouldn't arise. Of course the UK could say we don't want our parts in the global pool to go to Israel. Of course these parts can be tracked. It's the most sophisticated fighter jet in the world. It's a supply chain where there has to be accountability. You have to know where the parts are coming from and where they're going to. So we said that argument didn't stack up, but unfortunately, that's the way the court has found it.
Yeah, we got to say it sounds pretty ridiculous from the British government to say that it cannot really track where the parts are going. Are they going to Israel? Are they going to another a lie. Uh, it sounds, again, it sounds very far fetched. But
Yeah.
I wanted to ask you. I mean, the case was launched. Was it on behalf of Al-Haq, a Palestinian? It was, right? On behalf
Yes,
or
that's
with
right.
Al-Haq? Yeah.
Al-Haq are the claimant in the case, and we're their legal team.
Yeah. So yeah, the case was launched by Al-Haq, which is a Palestinian human rights organization, in December 2023. Can you maybe give us a bit more details about what the case was about when you?
Yeah, sure. So the case really has been in two parts. When it was launched at the start, up until there was that really changing point in September 2024. And the case has always been about saying that the government's licensing of weapons to Israel is in breach of international law and also domestic law. Initially, we were challenging the way the UK government was making its assessments of Israel's compliance with international humanitarian law. The UK government was adopting this methodology in which they would say, we have to look at individual incidents of concern, this one airstrike, and make an assessment of whether that's a possible violation of international humanitarian law. And to do that, we need information from Israel about what they were targeting and things. And what happened with the government applying this method is they weren't getting information from Israel, and they were not looking at the patterns. It only assessed, up until September 2024, 413 incidents out of thousands. And of these, it found one single possible violation of international humanitarian law. And that was the strike on the World Central Kitchen, in which white people were also killed, and in which Israel did have to provide information about it. So the government, because of the method it was adopting, put itself in this position of saying, we don't have enough information, we can't tell. So we can't really say what's happening. So we say it's engineered a state of willful ignorance or blindness. It is refusing to properly assess what is actually happening. It's saying the craziest things, like there's no evidence of women and children being targeted, and therefore we can't conclude that there's a serious risk of genocide. But it has that evidence. It's just not considering it properly. After the decision in September 2024, we argued that challenge to that methodology was still relevant to the case. But a judge in January said that it wasn't, and the case became only about the lawfulness of this F-35 carve-out, whether it was consistent with international law obligations, like the duty to prevent genocide, and whether it was lawful under UK domestic law, whether the government had a good reason to depart from its own policy, because the government accepts that under its own policy it should be stopping, but it just says that it has this good reason to depart from the policy because of the implications for peace and security. So the case became narrower, and unfortunately we weren't able to challenge what really is the heart of the problem, this refusal to properly assess what is happening.
And it's even more frustrating, and I'm using this word, I could use like stronger words, because at the head of the UK government, you've got a former international law expert,
Yes.
Keir Starmer, that knows better. I mean, like, for the government to say, after more than 20 months of what many call a genocide, with more than 17,000 children being dead, with more than 55,000 people being killed, with pretty much every hospital, every school, every mosque, every cultural center being destroyed, still wondering if there are potential breaches of international law seems I don't have I can't find any words to describe this from an international lawyer as well.
Yes, absolutely. And not just our Prime Minister, but also the government's Attorney General, who's their legal advisor, is also an international law expert who frankly should know better. And when they came into government last year, they said this is the government that respects international law. decisions made have to be consistent with international law. And then it went to court, and it said to the courts, these international law arguments, they're not for you to consider. The UK is a dualist system, so that means that international law obligations that aren't specifically incorporated, shouldn't don't automatically form part of the UK laws. But it doesn't mean there are exceptions to that, and we say that they apply in this case. So the government really, the second key part of their defence, other than the national security approach, was to say to the courts, just don't go there. This is none of your business. This is a matter for Parliament. And yet it's been saying to Parliament all along, our arguments are being tested by the courts. So we're not telling anything. This is not the place for scrutiny. It's been decided by the courts. It's been trying to have it both ways. The courts now say clearly this is the matter for Parliament, and we hope that Parliament will now take up the baton and fight even harder to hold the government to account, and of course the public too.
Yeah. So the Attorney General is Richard Hermer KC, right?
Yes, that's right. Yes.
Yeah.
Yes.
Yeah. This is also, I gotta say, this is very surprising. I mean, I don't know if it's surprising, but it's because I remember when he was named Attorney General, a lot of people, including myself, thought this was a very good thing. So anyway, but I guess when it comes to Israel, everything is different.
Yes, absolutely.
Yeah. But
Yes.
so what does this say about who the government is actually accountable to in matters of international law? Because like the government says we need the courts to decide, and the court says you need the government and the parliament to decide. So yeah.
So, the court is saying very clearly that under the UK's unwritten constitution, it's for Parliament in this case to hold the government to account. That is potentially something on which we might consider an appeal, because obviously we thought there were strong arguments why there was an exception to the general position in a case of this kind of importance. But it's very clear now that Parliament needs to step up and hold the government to account. And we know that some members of Parliament will be pushing for a vote and trying different ways for this to be held accountable. But I mean, they have been trying already. So in some ways, it is hard to see where exactly we go from here. But they will try everything for sure.
And I mean, one of my last question is how that, because the government seems very reluctant to actually ban completely weapons or arms sales to Israel, who is a country which is committing genocide and has been for the last 20 months. On the other hand, the government is very vocal and very willing to criminalize speech at Glastonbury, and to go even further with, for example, the proscription of Palestine action
Yes.
that he wishes to put on a kind of terrorist list. So how does the two fit together? They
Yes.
don't, I know, but
Well, they don't, and they do, in the sense that it's a government that is unwilling to be scrutinised by the courts, by Parliament, by the public. And in relation to the public, they're really trying to stifle that. And there's a massive, in relation to Palestine action, there's a massive difference between direct action that's non-violent, that's a form of protest, that there's a rich history of and is fundamental to a democracy, and terrorism. And the government is conflating them shockingly, and seems really intolerant of this kind of dissent.
So again, my last remark: you don't know yet the next steps in terms of this legal action. You discussing and thinking about a potential appeal and to see if there's grounds to appeal. What are in saying so, what are the next? I mean, because we have to remind people that the goal is to stop a genocide. It's quite an important goal. So, what are the next step you think in terms of the legal potential fight, but also, in your opinion, what can people do? Because as you were saying, uh, there's been hundreds of thousands of people in the streets for the last 20 months. All the recent surveys show that 70 to 80% of the British public wants arms to be banned to Israel. So if we still live under democratic principles and democracies, what are the logical next step that we can do and that maybe the legal experts like you can do?
Yeah. So for sure, we'll be considering an appeal. We'll be working with MPs who will be using every method that there is in Parliament to try to seek a vote, to ask questions. We'd encourage people to write to their MPs and to say, what is the government's position now? This case, the court was analysing the government's position as of September last year. Things have changed massively since then. Things have got so much worse in terms of what is happening. We have not seen we've seen the government's assessment of whether there's a serious risk of genocide from last summer, from July last year. But what is their assessment now? So pushing for that to be revealed, challenging that through every mechanism that there is, demanding if they're saying this is for Parliament, if they're continuing to say there's no problem here, holding them to account on their own words, which recently have been stronger in condemning Israel's action, and saying these need to be backed up now by action. And we know that the law is one tool that we have, and it's an imperfect one. It's a slow process. It's very important, and this case has really done so much for galvanizing people, bringing them together, for revealing the government's position, and that giving tools for people to take action. So we need to continue all of that, but we need all forms of action, really, for a moment so important for Palestinian people.
Thank you, Jennine. Thanks again for your work. Obviously, I know it's a collective process, at GLAN, but yeah, thanks again, and yeah, good luck with everything. Thanks, Jennine.
Thank you, Frank. Thank you.